Welcome, everybody. We'll get going here in just a second. We changed it from a webinar to more of a meeting format by design because we want to get some feedback from all of you while James is going through some of these morning briefings. So,
welcome. So yeah, we definitely want to make this interactive. And as those that have attended other legal or leadership and legal live events, we want to talk about all the elephants in the room, all the hot issues. And naturally, in the first 105 days of the Biden era, there have been a lot of changes and a lot of proposed changes that will happen in the future. And I'm going to cover those in about 20 slides. But before we do that, we actually want to warm up the audience and make this interactive. So we're going to go around quickly the room and we're going to identify who you are, what company, and is there any one key issue you want to be sure is addressed today. And we're going to start with our people that actually showed up in person first. So I'm going to hold the mic for COVID sanitary reasons, but you can talk to the mic. I think it's on.
Okay, hi, I'm Emily Henricks.
Is that working? Yep.
Okay. I'm the Human Resources Manager for Oakland Industries. I don't have any specific questions or concerns, but interested in learning what happened with the recent act that was passed.
Excellent.
I am Elizabeth Williams, the Corporate HR Director at Aerotech Corporation in Ann Arbor, and I'm just, like Emily, wanted to keep up with all of the new laws that we have to follow.
Excellent.
Hi, I am Brittany Crossing. I am one of the client relationships managers here at Qualligence.
All right.
Scott Wilson, I manage our executive search group here at Qualligence.
Pleasure. I'll come around.
I am Jennifer Ryzik, and I'm the marketing director here at Qualligence.
All right, and I hear someone walking down the hall, so we're gonna have an impromptu guest. Here she is. We're introducing ourselves and our company.
My name is Ann Young.
Is this?
I think it's on.
It is?
Hello?
Hello, welcome.
Hi, I'm Ann Young, and I'm with Gallagher, and I am happy to be here at the Qualligence International Headquarters. I've never been here.
Welcome. Good to see you. Pleasure. And hello.
Long time no see.
Long time no see. Thanks for coming.
Am I saying something?
Yeah, you're saying your name, your company, and if there's anything you want to talk about today.
Oh my goodness, right on the spot. Okay, my name is Alexandra Soyubek, and I work for Plantera, and I'll probably come up with questions as we go. Nice to meet everyone.
Excellent.
Thank you.
There's food here, and Papa C. And now we have people online.
we have a lot of people online, and we're going to kind of go through in order here. Susan, you're first online. If you hear me, introduce yourself and any additional questions.
Good morning. My name is Susan McCoy. I'm calling from Delta Technologies.
Oh, Susan's on iPad, so it might be more. Can you actually? Can we hear you?
Maybe we'll just do people that have their cameras on, and then the rest can put their comments in the chat box.
Fair enough. Put your comments in the chat box. Ed Holinsky, you're on there. Tell us where you're from, Ed, and a couple of things that we've got to address for you today.
Yeah, good morning. I'm glad to be with the group. I'm with Vistage. I chair a CE group and a key leader group, and I'm interested in how these changes might affect primarily small to mid-sized businesses on behalf of my members.
All these changes on small to mid-sized businesses. James is definitely going to cover that.
Good morning. I'm Heather Lenz. I'm with Challenger Gray and Christmas. Most interested in knowing about the changes with Cobra.
Changes with Cobra. Awesome. Hey, if you guys have some background stuff going on, if you could put it on mute would be great. Pat, you're next.
Thank you. I'm Pat Gammon from Petoskey Plastics up north, and just interested in kind of networking and finding out what's on people's minds. We've got a crisis in labor, and so looking at ways to solve the retention issue.
Retention issue. Awesome. Thanks so much. Shelley, you're next. No last name.
Good morning. I'm Shelley with Decco, Shelley Gunther. So I do have a last name. Just here this morning to soak up whatever information I can, actually.
There's going to be a lot of it coming at you. Mr. Bomser.
Good morning, David Bomser from Northville, interim HR leader, and here to network and help others where I can, and a little bit of self-development to keep up on the current topics.
Awesome. Thanks for joining us, David. Who else am I missing with a actual video? It looks like everybody else is not on video, but that's okay. So I'll take a look at all the comments and I'll keep that going, James.
Yep.
But Biden has been in office for how many days now?
I think it's 105 as of today.
Okay, we have 105 as of today. Let's talk about, why don't you go right into some of the changes that are happening? Because I think that's what most people are here to actually see, because that's what we actually put out there. If you want to use some of your slides, great, David. We'll move the camera so everybody can see it.
Sure.
But I think jump right into this. I'm gonna keep tabs on all of the comments.
Sure. So, in a nutshell, we obviously have a Democratic president. And historically, when you have a Democratic president, it shifts from pro-employer to pro-employee. So we're seeing substantial changes benefiting employees and in various ways making it more challenging for employers. So one major benefit for employees is they can get more unemployment benefits through September 6th. So it's essentially double the unemployment benefits. So right now, I hear a lot of companies having challenges getting employees to come back to work or even hire new workers. And part of that reason is if you can make over $600 a week on unemployment, it's a little challenging to want to work for similar pay at work. A second major development is the National Labor Relations Act. So even though most employers don't have union employees, even though several of you live do, and some of you on the webinar I know do, for those companies that don't, private employment employees without a union still have all the same rights as unionized employees. The National Labor Relations Act applies to non-unionized employees as well. Any employee that wants to engage in concerted activity to improve working conditions is free to protest, talk about the company, and try to even complain about management and demand more pay, more sick time, more changes, and you can't retaliate for that protected activity. I'll go over in detail as to what those major changes are. There are drastic expansions to the Affordable Care Act, and someone on the webinar mentioned COBRA. Now anyone that is laid off after April 1st, the employer has additional obligations to pay for that COBRA so that it's more affordable for that employee to still have health coverage at a reduced cost. And we can get into more details of that as well. There's also the PPP loans that have been extended. They were supposed to expire on March 31st. Now they're extended through May, and there's still about, I think, $60 billion available for those PPP loans. And in general, the PPP loans and the Family First Coronavirus Response Act are only supposed to apply to companies that have 500 or less employees. So Ed Holinsky mentioned, small, mid-sized businesses. If you're over 500 employees, you are not eligible for those either PPP or FFCRA. And what's even more challenging is now some of these relief packages are optional. So going forward, employers are not required to have 10 weeks of paid FMLA or 80 hours of paid sick leave. It's optional. And if you choose to implement that, you can get a tax write-off so that you don't have to pay out of pocket to opt into that relief package.
So what's the incentive for a small business to actually do it? I get the tax relief, but beyond that, why should we provide paid FMLA if we're under 50?
Essentially, some companies pay for FMLA or sick leave generously, so that way it won't cost the companies out of pocket if they would otherwise want to pay when employees are having that leave. And some companies want to incentivize employees to get vaccines. So an amendment is now you can actually have paid sick leave if you're having a reaction to a vaccine, or if you need to miss work in order to get a vaccine. So you may want to opt in to encourage your employees to be vaccinated.
Is anybody here under 50 employees and offering it? You're over 50 employees, well over. Okay.
But we're continuing that benefit.
You are continuing that benefit.
Is anybody electing not to opt in? They could?
We've opted in.
Okay. So let's go over these slides. So not everything has happened yet. So even though I gave you those updates that have already occurred, there's now a Democratic majority. So any new proposed legislation, they have the 218, the 212 votes. There's now a Democratic majority in the Senate as well. And right now, the Supreme Court is a majority Republican, but I just saw in an article this morning that there's a hard push where they want to propose adding 4 more Supreme Court justices in order to make it a majority of Democrats at the Supreme Court. And
Do you think that will pass? Because I just heard on my way.
I think it's unlikely to pass. I think it's, historically, former presidents have tried that, and it's frowned upon to try to, I think, recreate the history of what has happened in our system. But it's hard to tell when you have all these other Democratic seats. It's also interesting to see, what new cases end up going to the Supreme Court. I think the biggest ones of 2021 will involve religion and how religious rights overlap with maybe other protected classes such as sexual orientation. That'll be the big clash of 2021. And Biden already replaced the head of the Equal Employment Opportunity Commission with a Democrat, and the head of the National Labor Relations Board immediately fired him and replaced with a Democrat. However, the EEOC, as of right now, is still a majority Republican on the seats, and same thing with the NLRB board. So it's going to take some time for those seats to open up. So a lot of things we have going on. We have the stimulus plan that I briefly summarized. We have the vaccines that are still ongoing. In Michigan, Governor Whitmer did not do any mandatory closings yesterday, but the numbers are higher than any other state I'm aware of in the country. There's the most pandemic-related litigation going on ever right now, and last year was the most EEOC claims filed in the last decade. So we're anticipating 2021 to be the most litigious year ever, and partially is because there's a backlog of cases where judges postpone things until this year. But in addition to that, a lot of employees were not at work, and now that they're coming back to work, I think a lot of you in this room are getting complaints like, I saw the president touch the coffee pot without wiping it off. So they're like writing up the president, writing up the CEO, and HR has to deal with my coworker, some put something in the refrigerator without wearing gloves. And there's a lot of these types of, write-ups and complaints being made. And I think it's creating a major culture issue where you feel like everybody in the company is working against you. If you have a runny nose with allergies or a sneeze, everyone looks at you like they give you that death look. So I think that, I'm open to the audience how to hear how to, improve your culture. And I think one tactic that I'm sure, Steve, we could talk about is, as a leader, you want to encourage your staff to communicate with each other and not just have to formally report to HR every time there's a minor issue?
Yeah, I mean, it's an interesting issue. Anybody who's seen my eye this morning? I got up this morning and I worked out, and I'd never done this before, but I popped a blood vessel in my eye when I worked out. Well, my wife looks at me and she says, you can't go on, if you're going to go to the office like this, people are going to think you're contagious and have pink eye or something along those lines, which it is not. But she was already thinking, because of all the COVID issues, that becomes a challenge. So no, I don't have pink eye. Yes, I worked out and I'm old, so I popped a blood vessel. But at least it's about having that conversation. To your point, the less conversation we have, the more we make assumptions. And that's one of the challenges that's happening across the board. But James, is there specific litigation coming out of some of that complaining, some of that assuming that we need to be aware of, that we need to be potentially dealing with?
Yes. So what happens is those same employees that are actually reporting to HR are actually less concerning to me. The more concerning employees are those that say nothing to the coworker, say nothing to HR, and they're calling OSHA. So that's my next bullet point. I have multiple clients that have had my OSHA come to their company multiple times. And it's solely because there's an inside employee complaining to an outside party saying, come investigate my company, come on in. And it's happening to a lot of good companies. And in order to be prepared for that, at a minimum, you would want to make sure as HR, you've at least provided OSHA training. So you need to have a recorded training, voice over PowerPoint. You need to have a laid out plan, and they're going to be asking for your logs. So like when people come to your office, are they completing a daily screening? So every time I go in the Dinsmore and log onto our computer, there's those, I think it's 10 boxes where I have to verify I don't have a fever, I don't have a cough, runny nose, etc. And the questions I'm getting is, we're almost zombies. Do we just check no times 10 and every single, and not even think what the questions are? And now with allergies, what happens if you check yes with a runny nose, or yes, I have traveled in the last 2 weeks? What's HR going to do? And the guidance is a little bit unclear. It doesn't say just because you check yes, I have a runny nose, or yes, I traveled, that you have to send them home. That's not the authority. So you have to come up with your internal plan of what discretion you want to take when someone checks yes to one of those boxes. But at a minimum, you're going to want to have some records, and the investigators are more interested in how did you handle a positive case. So they're going to want to see some evidence where someone said yes to one of those boxes and how you handled it to show that you are providing a safe work environment.
Hey, James, there's a question. Has MIOSHA changed the rule regarding wearing a mask?
I'm not aware of any changes. Even if you're vaccinated, you have to wear a mask. So all of us in this room have to be 6 feet apart, and otherwise you would have to be wearing a mask. And I have been vaccinated, and I'm trying my best to stay 6 feet apart. There are some exceptions if you are presenting where you can take off your mask and other events. And there's also exceptions where if you are sitting down and eating, or drinking coffee.
Up to 6 people at a table, so on.
Exactly. So there are some of those exceptions, but no, in general, you would wear a mask in the workplace setting unless you were in your own office, then you would not have to.
You'll walk around the building and very few people here are wearing a mask because there's 17,000 square feet and there's like 10 of us here. So it's really not an issue, at least not for us. But our team as well, every time you come in, you got to take your temperature, you've got to sign. We don't have it on our computer, but you do have to sign before you walk into the building for that exact reason.
So Biden's stimulus relief plan passed. It's a $1.9 trillion package. And there's many updates involving Affordable Care Act, vaccines, et cetera. But the ones that involve employment are the $300 per week of unemployment insurance boost through September 6th. And that September date was longer than what was anticipated originally. So just be aware of that. However, on April 1st, April Fool's Day, I was getting these calls saying, James, am I getting punked? Is this a trick? I'm now getting charged by the Unemployment Insurance Agency for all of these unemployment claims. Because prior to April 1st, employers actually would not get charged if it was a COVID-related layoff or COVID-related missing work or COVID-related unemployment. But going forward, the state said you're now going to be liable and responsible for those charges under your unemployment history account. So therefore, that may be another reason for those employers that are under 500 employees that would want to opt in and maybe pay those employees the paid sick time or FMLA, so they're not also hurting the unemployment history account. For those that aren't familiar with the unemployment tax rate, a lot of employers are becoming aware of it for the first time. So every December, you get a tax rate determination that's between 0.3 and 10.3%. And on that 10.3%, you would pay that percentage towards the first $9,000 of every employee's wages across the board. So if you do simple math, it's around $900 and change per employee. And usually that is fully paid in the first quarter of any year. So that's how you kind of calculate your max unemployment liability. And if you pay out more than you have in your reserve account, your rates will continue to be at the max. If you pay out much less than what's in your reserve account, your rates can go down over time. A lot of people have received their $1,400 per person stimulus check. There's also additional checks for having dependents. For those of you that make over, I don't know, 200,000 or some threshold as a family, that's when you would phase out of the eligibility. As we went over, the FFCRA leave was not reinstated, but you still have the option to opt into those perks all the way through October 1st of 2021. All right, so with vaccines, I'm getting a ton of questions like all of HR is trained that when someone says, you know, they're not feeling well or they're disabled or they have this issue, you're always trained. I'm not supposed to ask, is it cancer? What stage are you in? Like, you don't want to know someone's diagnosis because you could be accused someday of using that disability against them in an employment decision. However, there are exceptions when you're in a pandemic. So you are allowed to do things you wouldn't normally do. You're allowed to say, let me check your temperature. Are you feeling well? You can ask these questions. And you could also ask, have you been vaccinated? So asking these questions are not considered a medical exam, and you could force vaccinations if you so chose without violating any laws, as long as you are open to exploring reasonable accommodations for any religious beliefs or any disability accommodation requests. So what I didn't say, medical beliefs are not a protected class. So if you medically believe that it's not good for your health, that is not actually a legally recognizable defense.
Are companies making it mandatory for employees to have the vaccination before they come back into the office?
So the question is, are employers mandating vaccines? And I'm not aware of any of my clients at the moment that are mandating it. You could, I think, I would imagine some hospitals are, and in certain settings they are. What I'm seeing more of is incentives. So like Kroger is pretty open about, if you get it, I'll give you an extra few days of PTO, or I'll give you a $300 gift card. And they're doing various incentives as opposed to forcing. My understanding is surveys across the country, about 50% of the workforce does not want to have it mandated.
Can you ask somebody for proof that they've been vaccinated?
That's another question, and the answer is yes. So you could ask to show proof of your vaccination card. And in some states, they call it a passport. And they actually have a laminated passport. And it's funny you mentioned that, Steve. Sean and I were talking about at the SHRM conference in October, we may offer a lamination booth to laminate your card if you so choose, so you can have your kind of hall pass to go out and about for those companies or events where people feel more comfortable.
So what happens, and this is from a legal perspective, I've thought of this, I've had this question asked to me. Let's say we were to mandate vaccines and Mr. Scott Wilson has a negative reaction and dies. Am I liable because I forced the vaccine?
So that is the question that's being asked, and
I'm not telling you to get it, Scott, just so you know.
Sure. So when there is a workplace death or injury, workers' compensation is supposed to cover that 99% of the time. It's outside very intentional, grossly reckless torts is kind of the exception from workers' comp. And so I think number one, workers' comp would cover that scenario. But two, I would argue his claims are going to be against the FDA or the Johnson & Johnson or Moderna or wherever they got the Pfizer, wherever they got the shot, as opposed to you, because you approved something that was, recommended and encouraged. And there are a lot of immunity laws. So Michigan actually passed an immunity law that as long as you have a responsible COVID plan and training, you actually have strong immunity defenses to anyone that dies or gets hurt at the company.
So we've got a couple of comments that folks are leaning towards giving 4 hours of pay to go get vaccinated. It's an incentive. Interesting.
It's an interesting incentive. I think that makes sense to me because you usually miss a few hours of work and you don't want them to make less money for advancing the cause that the employer wants them to accomplish.
Are the vaccines technically federally approved, or are they federally approved for emergency use only?
I'm not a doctor, and I assume they were, but I never looked into it.
It was a question that came up yesterday.
So I recently was asked if insurance companies, I heard, are possibly going to not approve claims if people got vaccinated because the vaccine is considered experimental.
Because the vaccine is considered experimental still.
So in your example, he wouldn't get his life insurance benefit. Oh.
That's interesting. Sorry, Scott. So this was brought up in a conversation that actually
validated it.
Right, that Ann and I were at yesterday, and I was having a side conversation with somebody that was with us that is not in COVID research, is in cancer research, and that was the question that actually came up because it was not technically, it has not gone through all of the approval process. It's for emergency use only, pandemic use only.
Interesting. So I guess the question in the room is, are you life insurance carriers out there going to deny life insurance for someone that has, a disability or death related to a reaction to the COVID vaccine? We saw with the Johnson & Johnson that there were some blood clots and
right.
At least 6 issues. And what's going to happen with insurance under those policies? I think even though I've seen technical arguments, I think in reality it'd be a bad social media blow to those companies if they didn't honor that.
Robert has a comment. Doesn't the new FFCRA cover the time off to get vaccinated and to take the time off afterward due to adverse reactions?
So the answer is yes, but the clarification I said is those laws are optional. The FFCRA is no longer forced in 2021, so the company would have to opt into that, and that would only apply to companies that are under 500 employees.
So is it, if you were in it, you still have to re-opt into it as of January 1 because of the law change?
You don't have to opt in formally, but yes, you would have to grant it to everybody. You can't pick and choose who you grant.
Good. Thanks for that comment, Rob.
Yep. All right. And so this answers Steve's question. Yes, you can require proof of a receipt. However, requesting why the individual did not receive a vaccination could be a disability inquiry, which would require the employer to meet the job-related standards. So maybe not get into the details if they say no, they didn't, because they may have a disability or reason as to why. It's very slippery. So another slippery slope is I'm seeing a lot of companies and clients of mine that are bringing a nurse on site to implement the vaccine at work so no one actually leave for 4 hours. And what the company was concerned about is if they use office staff to complete the initial paperwork for the nurse or ask certain questions, is that a medical inquiry? And the answer is yes. So you do not want to play nurse and help them. You want to have the outside party handle the process from A to Z. And yes, you can force it as long as you're aware of the disability and religious accommodations. So you may be thinking, what are possible religious and accommodation scenarios. One is some of these vaccines are tested on animals. So if you have a religion that is purely vegan or a disability that doesn't allow to have certain chemicals in your body, those could be reasons where an accommodation would be necessary. What else I'm seeing is what happens if you have severe anxiety or stress about getting the shot. Could that be a disability that you would have to accommodate other ways? And the answer is to all of these is yes. You know, this is gray area, and you would, no matter what, want to engage in the interactive process and see if there's a way to solve that issue. Maybe if they're stressed out, maybe you give them more facts to become less stressed out, or you explore other alternatives.
Go back to a comment you said earlier, James, because there's a comment about that as well. Making accommodations, somebody who has a religious exemption, for example, to not taking the vaccine, and we tell everybody you have to take it. What's reasonable accommodations?
Great, so it's a great question. So the obvious lesson of 2020 that a lot of companies learned is, step one, you have to engage in the interactive process. So part of the accommodation process is you have to have a deep conversation with the employee and ask the employee, do they have any solution that they could provide to you? Because we're not doctors in most scenarios. So what solution can that employer or their doctor propose for us to evaluate? And if the doctor proposes something, we don't have to accept it. We can propose any other reasonable accommodation that we see fit, and whatever we pick prevails as long as it's reasonable. But some accommodations could be, why don't you take another 2 months working remotely because maybe COVID will be more under control by then? Or how about you come into the office during off hours and use our equipment and technology in the office when other people are not there? Or how about I give you this private office space that you wouldn't normally have, and you come into the office and I have certain setups where maybe you have a special entrance where you will have less opportunities to potentially even be exposed to COVID. Or you'll only have people on your shift that have already been vaccinated, stuff like that.
Good. Will you, I don't have LinkedIn up in front of me because I'm not that good.
Salvador says USA waives PTO for the day vaccines were approved with EUA. NFL mandated.
NFL mandated?
NFL.
I'm thinking football, but I think that, it sounds like some companies are paying for the day is what the comment sounds like, which is normal. I'm getting a lot of questions about how to pay employees a little extra incentive. But the trick is, under the Biden era, Biden is extremely aggressive on overtime and paying workers more. So what Biden did, I'll get into a little later, is he took away all of the safe harbors under the Trump era where companies could ask for help and training and fix their problems and report potential issues and get them fixed. Biden's saying, no, not anymore. Whatever we catch, we're gonna enforce and sue and take action, and you're fully liable even if you self-report. So the concern is, if you pay someone hazard pay of $100, do you now have to factor that into overtime? Because if you pay anybody any bonuses or commissions or additional pay, they're no longer a $15 an hour worker. They're now a $16.25 worker. So if they work 40 hours, are you paying them that extra time and a half is a complicated issue that is happening in the workplace. And people that have a disability or that have a religious belief, if they're not getting that extra $500, they're now saying, I'm being set back because of my religion or because of my disability. How are you going to make me whole? So it's kind of like those sweepstake cases where, no need to buy it in order to be eligible for the sweepstakes if you want to still be eligible. So I guess you would still want to find a way for those that couldn't participate to report that to you, and you could evaluate a way to treat them fairly. Like some companies are offering, I think, Pelotons to employees, and what happens if that employee has a disability where they couldn't utilize the Peloton. What are the options there? So there's still a lot of new complicated scenarios that come up.
Wow, that's an interesting one. I hadn't heard the Peloton one, but sell the Peloton and
That's
buy
what
something else?
I said to sell the Peloton, what's the damages there? So some of these are a little bit academic because in order to have a real case, you need to actually have monetary damages in order to make it worthwhile to actually spend the time, energy, and costs to pursue litigation.
So go back to the overtime rule, just because there's questions coming up about who do you have to pay overtime to, the difference between exempt and non-exempt specifically here in Michigan, because it keeps kind of moving, it seems.
It keeps moving. So, the best example I could probably give is one that Elizabeth and I just discussed, is that a lot of companies had employees that were properly classified as exempt because they're receiving a salary that was sufficient. I think it's like $40-some thousand is the threshold. And they had responsibilities that were sufficient. So most companies know how to comply with the salary test. It's the responsibilities that is the major issue. And because of COVID, some employees that were getting salary and managing 2 or more full-time workers, during COVID, they're not managing 2 or more full-time workers. They're working remotely, kind of working in their own silo, or some of the responsibilities changed during COVID. So currently they're not properly classified as exempt, and we have to convert those employees back to hourly. It's always legal to pay someone hourly and pay them time and a half for hours over 40. Where you get in trouble is if you pay someone a salary and they don't have sufficient job duties to be exempt, where they're still entitled to overtime. So examples of sufficient job duties would be manage 2 or more full-time employees, have significant job discretion in hiring and firing and day-to-day decisions. You're a professional, lawyer, doctor, architect, engineer. Outside sales is another major issue. If you're the mortgage loan officer at a bank or at a mortgage company, you're not outside sales, you're inside sales. So you have to be outside sales to be exempt as another opportunity. So under the Biden era, he's looking closely at any type of misclassifications. And if I call my secretary, my executive VP, that's not sufficient. They're gonna peel back the onion and realize her job duties are more like a secretary and she would not be exempt. So I'd have to pay her overtime above and beyond any hours worked over 40.
So what kind of other, I get the professional jobs and so on, but what's the other responsibilities somebody could have, like practical, that would make them considered exempt?
Typically anyone with the title manager, and most of the time the title assistant manager. So like at the fast food places, at McDonald's, Jimmy John's, etc., the assistant manager often manages 2 or more people beneath them, but sometimes the assistant manager doesn't. So the assistant manager is usually a gray area, but anyone with a VP title, really anyone that isn't doing hard labor. So if you're a blue collar worker digging ditches, no matter how much you're getting paid, you're gonna be entitled to overtime.
What about a recruiter that's doing things on their own by themselves? Or an HR generalist that's doing things on their own by themselves now?
I would argue that most HR generalists and recruiters could be exempt if they have certain discretion. So a recruiter may be able to negotiate a contract and change slightly the payment terms or some other provision, or the HR generalist is able to implement strong discretion in hiring and firing decisions and disciplinary decisions. So under those cases, I would say most likely yes. However, it's not what do I say. You'd have to go look at their job description. So now is the best time to re-look at the job descriptions and see if they have the buzzwords that match. There's basically 5 main exempt tests. Make sure the buzzwords match at least one of those 5 exempt tests. And in addition, interview people in that position and say, is this true? Is this just fluff that the lawyer put in there, or do you really have that authority?
So I've got a comment and I guess a question, and it says, we are a small office of 29. Our staff survey shows 25 of 29 employees intend to be vaccinated. Our CEO wants to require those that are not vaccinated to wear a mask even while at their desk in their own private cubicle. I feel this is singling those out and is essentially exposing their private medical information. Thoughts?
I do have concerns as well. I've not seen authority that because you've been vaccinated, you no longer have to wear a mask in the office. So I think that it would be inappropriate to single out people if it wasn't applied equally to all.
Okay.
And I think there's still evidence that even if you are vaccinated, you could still spread COVID as well. So that would not be a plan I would recommend.
There's no foolproof solution right now.
That's right.
Okay. Yeah, many people don't agree with the CEO.
It's a dangerous thing to treat people differently.
It's like the Scarlet Letter. You didn't take it, you're bad.
But part of it is academic. So if everyone's still getting paid equally and still employed, what is the adverse action? I guess the adverse action is being singled out, being exposed to disabilities, but I think a lot of people that aren't vaccinated isn't solely for disability reasons.
Sure.
All right, so what am I seeing right now with active pending litigation? I honestly have I have 5 lawsuits right now just on FFCRA litigation, because what happened is employees would be allowed to work remotely, and they would say, I have a kid with remote school, I'm just gonna basically do minimal work, not meet my deadlines, and if you fire me, I'll sue. And then those employees were fired by not keeping up with their job responsibilities when working remotely. And there was some flex leave concepts with FFCRA where if you allow people to do their job during off hours, early in the morning, late at night, they really don't have a good faith excuse not to get their job done when they are not sick or unable to perform their duties. So there's a lot of litigation in that regard. There's also litigation who was granted the privilege of working remotely. One client of mine, prior to becoming a client of mine, said that if you're a woman, you can work remotely. If you're a man, come in the office. Because if you're a woman, I understand you have, duties to take care of children going to school, but the men come to or if you don't have kids, come to the office. That would be an illegal rule to implement. That CEO didn't realize that under Michigan law, family status and marital status are specific protected classes under the Elliott-Larsen Civil Rights Act. So don't make a bright line rule with with protected classes as part of your rule.
What would be a non-protected class that you could create as part of a rule? Is there one?
I have seen some companies that say, marijuana users have this because it's still illegal under federal law. I have seen people that, academically in some cases have done other bright line tests, but typically the best way to do it, like I joke and say, if you went to U of M, I'm doing this, went to Michigan State, I'm doing that. Theoretically, those are not protected classes. You could, but I don't recommend that because what happens if there are more minorities under one school than the other or more women? They could say that was a pretext for actual discrimination and for a protected class. So the best way to do it is focus on the job description or job performance and say people that are evaluated this and above get this perk, evaluated this and below get that perk, or this job title gets this. Or what else I'm seeing is alternating. I'm seeing, we're having our admin alternate every other day, so there's always half of the amount of people in the office, but they're still getting some remote and some in person.
How are you guys handling remote? Is there a policy? Is there anything in play? What is it today?
Rotation schedule.
You got the rotation schedule?
That's
and you guys are all at home?
Yes.
Yeah.
Yep. Not even allowed to go even if you choose to.
Really?
Yeah.
Not even an option?
Nope.
What are you guys doing?
We have a blend, so there's rotations, and some people have been granted to work remotely.
Permanently? Okay, so rotations as well. Yeah, we've left it open. If you choose to work at home forever, feel free. If you want to come into the office, as long as we can be socially distanced, come on in. But I don't think we'll ever go back to the way it was.
Yeah,
Same thing. Yeah. But I get there's some roles that you have to come back. I mean, it's just the nature of the business. Understood.
So we're a blend for the professionals, attorneys, it's whatever you want to do. For the administrative staff, it's rotational because they need to access certain equipment like our giant printing machines and help us with the paper files and stay organized. So it's a little bit of a hybrid. I'm also seeing litigation on what happens when you need to request leave after your FFCRA expires. What happens after 80 hours? You think you have COVID all over again. Or you say, I have a sniffle, I'm going to Traverse City for 2 weeks to get another 2-week vacation. You see kind of both sides, right? And how do you handle that? And sometimes there's a judgment call of who you think is gaming the system. You see on Facebook, they're in a limo at some party when they were supposedly, deathly ill. We're also seeing non-FFCRA issues where sometimes FFCRA isn't triggered, but Family Medical Leave Act is triggered, or the Americans with Disabilities Act is triggered. Or for those that haven't been aware, in 2019, Michigan passed the Michigan Paid Sick Leave Act that also has 40 hours of paid sick leave. So you want to be aware of how all these overlap with each other. So now is a great time to kind of have a cheat sheet, missing work policy and probably recirculate it across the office. For those companies that are still doing some restructuring, a lot of companies are doing layoffs and they aren't aware of certain laws they never had to look at. So under the WARN Act, if you're ever laying off a 30-year company, or this applies to companies with over 100 employees, you have to give employees at least 60 days paid severance or 60 days advance notice before you just end their job.
That's a tough one to stomach because you don't have the dollars to spend, but yet you've got to pay 60 days in order to lay them off.
It's a very tough one to stomach, and there are some arguments you could make that whenever there is a act of God, they call it, that's the legal term for like a unforeseeable circumstance, sometimes you can waive your requirements to apply with a contract or certain laws. So I think they would argue that it wasn't their business, it was something unforeseeable given COVID. So there are some pandemic arguments that you couldn't perform your contract. It wasn't the company's fault, it was an act of God's fault. So we'll see how that litigation plays out as well in 2021. We're also seeing a lot of safety litigation for not, following all of the MIOSHA rules, and we're seeing more whistleblower claims. So for those of you that aren't aware, whistleblowing, you have 90 days to report your company to an outside body, and if you do that and you get terminated for doing so, you have to sue within 90 days, and that's called whistleblowing, in order to seek relief. Most companies think that, or employees think that when they report something internally, that's whistleblowing. That's not whistleblowing. So that's just the legal distinction. So make sure you're all keeping your OSHA logs for any cases that you have, and you're continuing to go to the Center of Disease Control website to make sure that you are following best practices. What's a little bit confusing is a lot of this is guidance as opposed to mandated law, and that's where you have some discretion. To give you an example, Steve, is people are going on spring break right now.
Yep.
And there is no mandate in Michigan that says if you go on spring break, you have to quarantine when you get back. But some companies are choosing to implement that because if you heard someone was in the Bahamas for 2 weeks and at beaches surrounded by thousands of people, are you going to be fine on Monday morning having them be in the office next to you? Those are discretionary things that you can decide how you want to implement that.
So have you guys done that? Somebody's going on vacation. Have you made them quarantine? Yeah, we haven't either. Just it's interesting that's coming up more and more and more and more, given the spike here in Michigan and the spike that happened down during spring break in Florida as well.
Exactly.
I was just down there, and I came back on Saturday and came to work on Monday. Luckily, I have nothing, but that's an interesting perspective.
Can I go back to the OSHA?
Yeah.
Was it the next slide over? Is there one more?
I'm saying may, but I'm really saying do it, because if my OSHA comes to your door, they're going to ask for these records, and if you have them, that'll be great evidence that you're fully compliant. If you don't have them, they're going to peel back the onion more and see what training you did, what plan you did, and they're going to interview other employees and ask what their experience have been. I had some clients where I actually did the training, did the plan, and then when my OSHA came to their site, whatever manager answered that door said, "We don't wear masks here, it's optional." And the manager obviously didn't actually watch the training that he was provided and didn't fully know the laws.
Did you know it was OSHA?
He knew it was OSHA, spoke on behalf of the company, and we ended up paying a fine to get out of that one.
So just quickly on that, we have everyone electronically fill out a questionnaire every morning, right?
Right.
I'm not going to give it to you because I don't want you to hold it. I'm going to hold it for you,
Okay.
near you.
And so my question is that so far we have had COVID cases at work. However, they've been caught prior to being on site. Like they've said, "Hey, listen, such and such in my family tested. Am I to come in today or not?" And our policy is do not come in, whether you have symptoms or not. Go get tested for your own sake and for ours. So we've been lucky enough, knowingly knowing that they have not been on site at the time they have self-reported, and we've asked them to stay home. For how many days? We ask them to stay home until we have a test result. So whether it's 2 days, 3 days, 4 days, 5 days, whatever, and we do compensate them for staying home for that time. So knowing that, that's not really an OSHA case because they weren't on site at the time they self-reported, because you must self-report prior to entering that building. So most people, obviously, being this electronic, you can do so on your phone prior to even leaving your house.
Right. So
for me, that's not a recordable case then in that sense, because we asked them already, do not come to work, stay home, and then we get the negative test, and then we allow them to come back to work.
I agree that you have not violated any laws based on my understanding of the fact pattern.
Yeah.
However, if you had 3 employees that all work in the same area that all called in saying, "I think I was exposed," if you have reason to believe it's work-related, that's when you would have a duty. And it sounds like in your scenario, it hasn't been that. It's all been isolated. Yep.
Separation of time.
So the answer is yes, but it wouldn't hurt to have a report even logging your investigation and how you came to that conclusion, so that when someone does come in, you can show you were thorough.
So James, related questions just for clarification that are coming up. So when employees diagnosed with COVID, that has to go on the OSHA log? No.
Only if it's work, only if they were exposed at work or had COVID when at work.
So what needs to be reported on the OSHA log? Only if it's work-related. What else is there anything else?
Or symptoms of somebody that is physically at work.
Okay.
And I would defer to the log itself and read. I'm sure it has, relatively clear instructions. And there's also this link. We'll share the PowerPoint after, but
we will.
My PowerPoint has links, so the enforcement guidance is available. So you can click, and it says it defines when a case is considered work-related. So.
A quick question on that though. Client side. So we have received, we've had an employee go on a client side, and the client has had a case of COVID, and they email out to the us, the company, to say, listen, on this date, we had a COVID case, this, that, and the other. And if we had one of our employees on site that day and later then tested positive, who's OSHA? It didn't happen. But the question is, whose OSHA responsibility log is it? Is it the company that has the COVID, or is it us who sent our employee there to service the client? Because it may happen.
I would argue in that scenario, both of you should have something in your log. And this example quasi covers it. It says if your employee has frequent contact with the general public, such as client sites, or multiple employees in close proximity to one another test positive, OSHA believes that alone is enough evidence to consider it work-related to report on a log. So frustratingly, OSHA does not provide clear guidance, and there are many alternative explanations of how someone could have contracted that disease. So there are some gray areas. But I guess I'll just err on the side of including it. Even saying maybe a disclaimer that you have no reason to believe it's work-related.
Yeah.
So unrelated to all of this, at the same time, Steve and I were just talking about, we're seeing a bigger push than ever toward diversity, equity, and inclusion. We're seeing, social media with Asian hate crimes, LGBTQ rights, and under the Biden administration on day one, he added protections to all people of America, including you can't discriminate based on LGBTQ status. So we're also seeing more federal contracting affirmative action. And we could spend a whole hour just on talking about the pros and cons of everything that we're seeing. And I would love to hear the questions that the audience has in this regard. Have any of you updated any of your policies involving protected classes or made any affirmative statements in response to what's going on with the various social movements?
It's a slippery slope. Because if you say you're for one and you don't mention another, that comes back to haunt you on social media. If you're completely quiet, that comes back to haunt you on social media. We've talked a lot about it's not a legal issue necessarily, but it becomes a social issue, and it's crushing companies. So how do you balance those two things?
Yeah, I'm getting a lot of emails actually saying, James, this company made this statement on Black Lives Matter, but did nothing on Asian hate crimes. So what message is that company stating?
But there's no legal obligation to say one thing or the other.
None. And I heard from the in-house attorney, or former in-house attorney at General Motors, they actually allowed Black Lives Matter pins, but did not allow LGBTQ pins. And I said, why is that? And they said, well, we tried to not allow any pins, but we were going to lose too many of our black workers if we didn't allow BLM, so we made an exception. So it's interesting to see what's going on at various companies.
I mean, that's just a lawsuit waiting to happen, right?
It's that's how it appears to be.
Oh, man.
So now is a good time to check and see if you have employment practices liability insurance and what your deductible is. Ford, it's probably $500,000 deductible, or they're self-insured. But for other companies, you may have a lower deductible. I think the common average I'm seeing is a $25,000 deductible. So what that means is the insurance will cover your legal bill and your settlement amount as long as it's solely related to the discrimination. They will not cover ever wage and hour misclassifications or overtime liabilities. So what the Biden administration did is created affirmative action plans, reversed the sensitivity training ban that Trump implemented, and is returning the right of refusal order requiring federal contractors to offer right of first refusal to employees of its predecessor. So on the first day of his office, Biden has an executive order that provides LGBTQ protections and any federal agency cannot discriminate based on sex or any type of sexual orientation, gender identity, or gender expression. I just saw an article yesterday that in Flint, they passed an ordinance that you cannot discriminate based on hairstyle. Because if you were to, some handbooks, would say you can't do maybe braids or certain things, and that could mean you're more likely to be a certain religion or national origin. So it's interesting to see the waterfall effect from these changes. So one clear example is I've seen in many handbooks, they have a dress code of how men should look and how women should look. You can't do that anymore because you can't discriminate based on sex or stereotype based on sex. What else I'm seeing is a push to, in your signature block or on your LinkedIn, is to encourage people to know how to refer to you. He, she, they, what is your pronoun preference? And even if you are not part of any minority protected class, they still want you to do it to make other people feel more comfortable to follow along, but I'm not seeing it mandated at most places. Some companies are prohibiting it because some companies have a signature block logo that they don't want changing from employee to employee. They have a brand that they want to show.
Yeah, we won't mandate that by any stretch. And we have a signature line this is what we use. Everyone uses the exact same signature line for that reason.
And it's funny, when I was in law school, they were talking about, like, the most famous case was like which bathroom the minorities had to use versus the white kids at school. Now we're back to the bathroom talk all over again. Trump, DeVos, and Biden are saying that children shouldn't be required to go to the bathroom with their biological sex. They should go to whatever bathroom they identify with. So this is going to be a controversial issue. We're seeing it, in sports. We're seeing it in the locker room. We're seeing it with bathrooms. But in general, at work, in Europe, I guess they've always had a monosex bathroom where any sex can go in it. It's more normal. But in America, they've usually had separate bathrooms. But I'm seeing it more common now to have, any sex can use that bathroom, or employees can go in the bathroom where they identify.
Do you see that being mandated to the point where our bathrooms here are set up, for example, male and female? They're structured a little differently.
Yeah.
If I'm forced to do that, now I have to redo all of my bathrooms, and there's an expense related to that. Do you see that happening?
I see the undue hardship argument there, but I think I don't see a problem necessarily if you kept it separate, but maybe just added a privacy wall a little more in both bathrooms so that people would feel less uncomfortable.
Got it.
But what you can't do is you can't create an LGBTQ extra bathroom and say if you're part of that class, you must go there. That's going back to discrimination, saying, black kids use this water fountain, white kids get that. It creates an illegal feel and discrimination. So, and then Biden is also saying those that do discriminate based on LGBTQ are more likely to discriminate on the basis of race, disability, or other protected classes. So wage and hour, a lot of you have independent contractors. Biden is trying to say, let's be more like California. And California is basically saying it's impossible to have an independent contractor. So California just had that famous case involving Uber and Lyft, saying those workers are employees. So even if you're a gig worker doing kind of a side hustle, that is still an employee classification. So likewise, all of your contractors, today, Qualigence ordered carryout. That arguably is an independent contractor because we're not in the restaurant business. But if he, utilized someone to advance his primary business, where he also had employees doing similar duties, it would be arguable that those have to be employees.
Is that in effect now?
it's in effect in case law. There's not actual express IRS guidelines have not changed yet. But I think that if an employee sues for a misclassification, judges are allowed to take the other authority as persuasive.
So if I go on Upwork, everybody knows what Upwork is. We're in the recruiting and training business and so on, and I find somebody that can recruit for a few hours because it's in my business. They're no longer a gig independent worker. They're now considered an employee.
So it's complicated. So what I gave you was one factor. It's called the ABC test. So instead of having that complicated 20-factor test, there's now a 3-part test. And one of the questions is the C is control. How much do you control that employee, their schedule, their hours, who they call, and are they free to also work on a bunch of other company work? And what I call is the James Reed test is, do you have your own independent entity, LLC, and are you invoicing? Because when I have auditors come to my office, if I show them an entity name with an invoice, usually they're not going to peel back the onion and ask more questions beyond that.
Got it.
I'm seeing a major uptick in pay equity. So during our job interviews, are you asking them how much money they made at their last job? And if you are, and you're paying them slightly more, but you're paying, maybe that person you're hiring is a minority or a woman, and other people in the company are paid more, are you continuing discrimination, or are you discriminating against that employee? And we all know a couple of years ago, they had EEO-1 reporting for companies over 100 employees, where you had to report the amount of pay based on race, sex, national origin. Biden is trying to bring that back. And California already brought that back. So for those of us that do business or have employees in California, we have to disclose all of those things. So now is a good time to maybe do a self kind of off the books audit, just to see if someone peeled back your onions, does it look like you're engaging in discrimination? But there are often legitimate reasons of why you're paying someone more or less beyond race, right? So if you are paying someone more or less, maybe write notes so you have some, logical reason as to why.
More experience, less experience, something along those lines.
Correct. Better results.
Yeah.
Yep.
So all that's okay as long as it's documented.
You're always allowed to discriminate for business reasons. So I kind of joke that I engage in discrimination every day. Over 90% of discrimination is legal because it's not based on race, sex, national origin. It's based on who's the best to get the job done, who's the best, person for the task. So.
And is that discriminating?
Legally discriminating. So that's the point. Yeah, this is like the biggest point I want to make. All companies, I hear the word discriminate, harass, bullying, retaliation. Once I investigate, even the EEOC will admit over 90% of the time, there is no evidence of illegal discrimination. What I learn is they're not accountable for all the mess ups they had. They have a different perspective of how great they are than reality. And I say, okay, you have AIDS, you're over 40, you're disabled, but you were late to work 3 times this week. You cussed at the client and didn't get your job done. Yeah, I know, but I'm also part of these protected classes. Well, that's not why your boss is being tough on you. So that is the part that is why so over 90% of the EEOC filings do not result in a finding of discrimination. And it's not all the employees' fault. A lot of the times the managers do a horrible job at holding employees accountable. They just give work to another rock star and don't really even bother dealing with that employee. And they think in good faith, maybe it was because of their age or protected class, they didn't know they suck. They were never, given the opportunity to sink or swim.
How is years of experience related to that? So think of our job descriptions that have 10 years of experience, 20 years of experience, and so on. Are you discriminating against somebody who has 8 years of experience and because it's business? Well, you don't even know if it's business performance related. You're just saying arbitrarily 8 years, 10 years, 12 years because the leader said that's what it should be.
It's very interesting. Michigan is one of the rare states that actually protects age being too young. So under federal law, you're only protected if you're 40 or over, but under state law, reverse age discrimination is also illegal. So if you had this job description that said 10, 20 years experience, but the attorney proved that a 2-year experienced rock star could outperform all these 20-year experienced people, they would have a claim as to why are you discriminating based on age.
What about organizations that are saying, well, we have to do that? Maybe they're a federal contract. I don't know if there's such a thing as that. So if we interview somebody who's only got 8 years and we said 10 years, now we have to interview everybody that has 8 years. Is that the case?
So these are more academic questions that I love, by the way, but that person that got denied that interview at 8 years would have to explain, show me the other people that still got the interview, what different protected classes are we, and why am I more qualified than the other people? And so it's very hard to prove, but yes, the point is anyone can bring a claim. So if you create any perception of unfairness or don't have sound reason or logic as to why you're making some requirement, you're opening up a door to be sued.
Is it better just to remove years of experience and focus on what they have to know how to do?
I agree with Steve's point, and I understand his logic. But I understand some companies that still want to do it. So to give you an example, I just posted an ad where I wanted 0 to 5 years experience to have a new lawyer that I wanted to train. Now, could I train someone with 40 years experience? I could, but I wanted someone that I could, show my style and my strategies to, and frankly, would be more accustomed to a more normal level of pay in that range. And if someone has already practiced, a lot more years than that, they should be a partner by now or have their own clients by now. So I wasn't discriminating based on age. I just wanted someone that was newer in the game. And I think that's for a legitimate reason. But I'm open to other points of view.
How do you guys view years of experience on a job description? The value or not? Thoughts?
I agree, it does come actually down to pay. It's always the bottom line, no matter how you look at this.
Comes down to pay.
It comes down to pay. I mean, you cannot pay, well, you could technically, if a full-fledged attorney of 20 years want to work at a very lower level cases and earn their rope in a new firm, sure.
You're right.
It's usually not how.
I don't want to get 1,000 resumes of people that I find out they aren't going to want the pay or the task.
At the bottom line is the pay kind of goes with years of experience. Does not maybe go with age per se, but
Right.
years of experience. I mean, I could be out of the workforce for 10 years, right, and then get back in the game, and technically I only have 0 to 5 years of experience, but I might be more a senior in age.
So what if you just post the pay instead of saying I need X years of
But
experience?
you also give away your, what you're willing to pay for talent, and a lot of companies aren't willing to do that.
The competitiveness of it, sure. Sure.
You also can't just look at years of experience, black and white. Years of experience are part of a whole slew of qualifications that sort of perceive what value you're going to bring to the organization. So I get paid more now than I did a few years ago because over the past few years I've amassed experience that allows me to be better for the company that I'm at.
But does years of experience equal a skill?
No, it doesn't always, but a lot of times it does. I think more often it is the rule than the exception that the more time you spend repeating a certain set of duties and responsibilities, the more you're honing that craft and you're therefore more competent. So
I see it come up less in your example on the lower end, and I understand what you're trying to do from a compensation standpoint, but the difference between somebody who's got 10 years or 15 years of experience, what if I learned in 8 years what took you 15 years, who's actually the better candidate?
well, you're right. Some people have 1 year of experience 5 times in a row.
Right.
They really don't. They've not amassed any new skill or competence. So, yeah. I mean,
You're right. And 1 year experience working with us might be 10 working for someone else that isn't
That's right.
giving them those abilities,
Yeah.
right?
It seems to me that, and I get what, and we do the same thing, especially on the lower entry level position, because it does become a comp banding issue. But on anything that's more professional than that, it just seems what we're focused on is I mean, we're a little off subject, but focused on people that can do know how to do something specific. What's that specific thing they need to know how to do? As opposed to, do they have 8 years or do they have 10 years? Doesn't really matter. I would argue that the one that learned it faster is probably the better candidate in the long run.
Going back to the data, I've been hearing a ton of candidates saying that, well, during my university or college courses, my professor saying that I should be going and making this amount. So sometimes you're hearing that these lower level or newly graduated candidates are expecting this much money compared to somebody with 5 years, because that's not how it was. Or even going back to the trade side, well, I should be making this much money. But you don't have, going back to the experience part, you don't have that experience compared to them. So the experienced individuals could be making a little bit less.
Yeah, no, I think my logic is similar to yours, Steve. I see it as, if you already have 20, 30 years experience and you aren't already an established attorney, I don't think I want you.
That's right. That's right.
Yeah. Right. You know what I mean? I want someone that still has upside potential.
Experience does not equal to skill.
So real quick, we only have about 2 slides left, and then we're going to have open discussion.
Yep.
The National Labor Relations Act is going to be changing. These cases are going to make it easier to have smaller subunion companies, like maybe one group of 4 employees could make their own union inside your company. They're going to make more joint employers liable. So they're going to make it easier to bring maybe the staffing company or the supplier or the GC and the sub all liable as the employer. And they're going to allow employees to use your workplace equipment and emails to engage in protected activity and solicit each other to improve working conditions. So be aware of those changes on the horizon. And this is just more detail explaining each of those 3 cases that I went over. But in that regard, you got to be careful on your handbooks. If your handbook says you can only use the emails for work purposes, and you find out people are emailing people, to Girl Scout cookies or whatever, Boy Scout stuff, and you don't fire them, but you fire them when they complain to someone about pay, now you just engage in discrimination. So be careful on your handbook policies. You're probably going to have to soften some of the policies to not violate the National Labor Relations Act. So I've had companies that got sued. They fired an employee, 3 employees that wouldn't sign the handbook acknowledgement. These 3 employees sued, saying, I never read the handbook, but there's probably some policy that's too broad in there. I would like you fired me because I didn't sign an illegal handbook. And now they want a year of back pay plus 5 years of front pay to find the new job. And this case is pending right now.
Really?
Yeah, so you want to make sure that your handbook is professionally prepared and has certain, examples of what your purpose is for that policy, so it's clear your purpose is not to restrict protected activity.
Unrelated question.
Yeah.
Unless there's additional comments specific to the slides.
We're done with the slides.
All right, question that came up. Any recommendations on running reoccurring background checks on all employees?
I personally am a fan of that because a lot of companies are acquiring other companies, and they don't always do background checks when they acquire, and they're learning that some of these people have, records, convictions, and they're seeing other similar issues in the company that if they knew that, they could have prevented that problem. So other employees are complaining, or they find out through Google, et cetera, about something. And also, it's a way to build trust. Employees should report when they're ever convicted of, a felony or have to go to jail or certain crimes. So it's a way to verify who's being honest and accurate, but it's not necessary in most jobs.
For somebody that's not doing ongoing, and they wanted to, what's the right cadence that you would recommend? Once a year, once every other year?
My off-the-cuff guess would be once every 3 years. To me, would be normal, unless there was some reasonable suspicion to think something was going on.
Got it.
I thought there was like a slight trend of moving away from some background checks unless it was like a bona fide reason. Like you can't have a person that was convicted of sex crimes working with children, or you can't have someone that was convicted of money laundering working in a bank. But there's some movement towards making sure we're allowing jobs for felons and encouraging.
There is. No, you're absolutely right. I'm seeing that there's a strong movement to never doing a background check again when someone's hired. There's a strong movement to not doing any drug testing during any hiring, and to never do drug testing once someone's hired, because companies that have done these things have found out some of their highest performing employees have cocaine in their system. Some of their highest performing employees, got 2 DUIs in the past couple of years, and you're wondering why they're getting dropped off all the time. But if you can perform all of the essential job functions at a very, very high level, you shouldn't necessarily care what's going on outside of work. However, for certain positions, I disagree. Right now, social media is more important to your brand than anything. And if they're doing things that would hurt your brand and the culture you're trying to create at your company, that would be a reason why you may want to do that every few years.
What about just stalking their social media and making a decision based on that? What happens?
I'm a huge fan of social media stalking, actually. It's funny, I actually have clients that call me and say, James, I don't want to hire people that have a highly active social media account, because if I ever fire them or they ever find an issue with my culture, I'm going to be bashed around the world. But it is legal. Michigan passed the Internet Privacy Protection Act of 2012, where we can no longer ask for their passwords to their Facebook, but we are allowed to publicly see what we can access. And I'm a big fan of doing so to get a feel of what they're like, because in Michigan and in most states, their off-duty conduct does impact the work brand.
Is there any potential litigation by doing that if they know you made a decision based on what you saw on social media?
The litigation I've seen is if you do a fake LinkedIn or Facebook name and try to, under false pretenses, friend them to get the inside scoop that wouldn't be public, that's a no-no. But publicly, you're fine from what I can see. I think in California and other states, they protect privacy. So if you learn something that for some reason they believe should be private, or the downside is you learn through Facebook stalking they're part of the LGBTQ class, you learn their religion, you learn they have kids, their marital status, or you learn they're cheating on their marriage. If you learn any of these things that arguably are protected, you want to make sure that you have a committee at your company that helps make the decision to terminate, not solely related to the protected classes that you have an unconscious bias about.
Yep.
I have a really great friend that interviews a lot, and typically they're newer candidates, and she will be almost done with the interview, and then she'll say, come on around, and she'll have Facebook and
Pull up their profile?
pull up your profile, and she will literally say, look at this is awful. They have, drinking and craziness. And, she literally won't hire them, or she will say, here's the deal, you need to clean this up. This is not acceptable, and is that okay?
That's fine as long as what she was doing is public.
Yes. Yeah.
And assuming everything she was doing on Facebook wasn't protected. That's where that National Labor Relations Act gets gray. There's no private free speech in private employment. First Amendments don't apply, but if he or she were trying to improve working conditions publicly, then that could be protected.
Yep. Well, we are right at about time, but if there's any additional remaining questions on anything that James has talked about or anything else related to the HR side of the business, you've got a couple of minutes if you want to. We can do the same thing online if anybody's asking questions. There was a number of others related to things that we've talked about in the past that I'm going to save for future ones. But if you guys have anything here from the local group, feel free.
And for those live, type in what topics or points you want us to address on the next one.
That's right. So James and I do this every month. This is our first one where we've done the hybrid, where some in person, some online. We're hoping to get to the point where it's all in person or mostly in person. I mean, that would be ideal depending on what happens with COVID. So if there's specific things you'd like either one of us to talk about, let us know. Email us, text us. We always put our numbers out there. For anybody who's watching, 734-837-8500 is my cell. James?
734-649, lucky 1313.
That's right. So we'll do it once a month. We'll let you know if you want to attend in person. We'll keep the location here. We'll try to get different locations as we go. as well. So we're not just in this little facility, but we'll go to maybe the DAC or some other place here, trying to bring together the HR community as close as we can to provide value to the HR community. That's really the idea behind it.
All right, thanks all for coming, and feel free to stick around and enjoy the food and beverages. I'll be around.
And if you're watching online, I wish you could join us. Make sure you're here next month when we do it again.
You're missing a hot spread of eggs, bacon, sausage, pastries, coffee, juice. Next time, don't miss it.
We'll see you guys later.
Main Street
Catering in Plymouth.
Supporting the local community.
That's
Yes.
right. Local small business that I'm sure got affected by COVID. So
Yes.
we're glad to be able to do that. Thanks, everybody.
Thanks, everybody. And the credits will be coming.